The theory in opposition to declarator theory is the original law-making theory. The main exponents of this theory are Lord Bacon, Professor Dicey, Justice Gray, and Professor Jurist Salmond. According to them, judges create an entirely new law. It is found in the common law countries. They played a creative role in moulding law. English law is sometimes called as judge-made law. So, according to them, it is the judge or judges who really make law. And the way of doing this process is found in all common law countries, and those common law countries are England, Scotland, Ireland, etc. So also those colonies which were under the British Empire. So according to them, the very process of lawmaking is with the judges. So not only they create a new law, they also mold the very provisions of that law. But the critics, they argue that lawmaking power is always with the legislature. But now we'll examine to substantiate the views of original lawmaking theory exponents. So judges are guided by certain principles, conventions and ideals. It is found that they do both, but their procedure is different from legislature. So actually the judges, they are guided by certain existing principles or conventions or ideals of a society, but their work is both creation, so also interpretation. So by creating laws in cases, they follow certain procedure, and that procedure of interpretation no doubt gives new shape, but that is nothing but law making in due procedure which is somehow different from legislature. To substantiate their point of view, we could cite a leading case, that is the Kesavananda Bharati versus State of Kerala of 1973, where we'll examine the views of Justice Matthews. Justice Matthews, in his view, expressed that judiciary is both creative and also an applying authority of law. It also formulates different standards, guidelines, and terms and conditions for the necessary implications and interpretations of laws. And by this way, the judiciary is not only the creative authority, it also the makers of law. In that case, to substantiate that point, their lordship invented the very concept of basic structure of the constitution. So, their lordship discovered and invented certain features of Indian Constitution to which they accorded the status of basic structure which could not be easily altered or amended even by the Parliament of India. In this context, we could analyze the very provision of judicial review or constitutional review as provided under Article 32 of the Constitution. So, nowadays, the judiciary, whether it is the apex court or the high courts, are so active in making law, so now it is identified as judicial activism.